Hi there, Kelly Longtin from Kelly Longtin Law here. And today we're going to talk about why unmarried partners should care about estate planning. Well, according to a 2020 survey, 7% of adults are now living with unmarried partners. So that's over 17 million people. More people are entering long-term committed relationships without getting married. And unfortunately, many state and federal laws do not protect unmarried couples as they do with married couples when it comes to inheritance and taxes and decision-making powers. Therefore, it's important that you engage in comprehensive financial and estate planning because without proper planning, your beloved partner could end up with nothing should you pass away. If you do no estate planning, your state's intestacy statute will determine who will receive your money and your property and the amount that each legal heir will receive. Intestacy laws vary state by state, but generally speaking, your money and property will go first to your surviving spouse if you're married, and then to your descendants, your children or your grandchildren, your parents, your siblings, and your siblings' children, in that order, depending on who survives you, although it works a bit different if you're in a blended family. If you had intended to provide something to your partner but failed to plan before the death, your partner will receive nothing under the law. In fact, unmarried partners are not mentioned at all in the intestacy statutes. If you have a life insurance policy and you fail to complete the beneficiary designation form, the proceeds from the policy may be paid to your estate, leading your family to endure the costly and time-consuming probate process, the court-supervised procedure that must take place to distribute your assets to your loved ones, and so bank accounts, property, anything you owned at your death to your loved ones. On the other hand, the proceeds may go to individuals according to the order outlined in the policy agreement. In many cases, the listed people will be your family members, not your partner. Similarly, if your retirement account does not have a named beneficiary, that account may also end up going through probate, which may cause unintended income tax consequences and distribution according to the default rules of the account agreement. In most cases, when we refer to blended families, we mean someone who remarries and has children from a previous relationship. In that instance, the planning objective is to make sure that the children from the previous relationship are not completely disinherited, because in many situations, the new spouse's claim to the deceased's money and property has priority. However, if you have children from a previous relationship, but you're not married to your partner, the concern becomes protecting your partner, who under the law would not be entitled to anything because your children would more than likely receive everything. When both married partners are U.S. citizens, each can give the other an unlimited amount of money or property during their lifetime without worrying about the federal gift tax. Unmarried partners who are both U.S. citizens are not afforded the same consideration. Therefore, you can only give up to the annual exclusion amount to your partner without having to consider the gift tax consequence. The annual exclusion amount in 2021 is $15,000, and it's adjusted periodically for inflation. Should you decide to give your partner more than the annual exclusion amount, you'll need to file a federal gift tax return to report the excess. On the bright side, the federal gift tax is not due until you have made gifts totaling more than the individual estate and gift tax exclusion amount, which is $11.7 million in 2021. Although the financial aspects of estate planning may be enough to motivate you to plan, there are also important personal matters to consider, including who will handle financial transactions on your behalf and who will communicate or make medical decisions for you if you're unable. If you do not name trusted individuals to handle your financial and your medical affairs, The state will apply its own order of priority and appoint someone. Depending on the state statute, your partner may not be on the list or may have a lower priority than your blood relatives. This situation can be incredibly messy if your relationship with your family is poor and you would not otherwise trust them to make these decisions for you. If protecting your partner is important to you, here are a few things you can do today to get started. Review your beneficiary designations. Remember, they must be filled out correctly to be effective. You want to review how your accounts and your property are owned. Living together in your house does not mean that you both own it. In addition, it's important to know who has access to the account that is being used for the household expenses, so the healthy partner can continue paying the bills if one of you becomes incapacitated or passes away. So give us a call to memorialize your wishes. Even if you already have an estate plan, let us review your documents to make sure that they still meet your needs. A comprehensive estate plan should address who will receive your money and property at your death, who will make financial and medical decisions for you if you cannot make them for yourself, and outline your end-of-life wishes. If you need help with taking the next steps to protect the future for yourself and your partner, give us a call. We're here to help you create a new estate plan or revise an existing one. So I want to thank you all for watching today. I'm Kelly Longtin from Kelly Longtin Law, where we provide effective estate planning for everyday families.